Y'all, it's Tuesday. I just got off of watching the contempt hearing for Tom Girardi's former partners, David Lyra and Keith Griffin. Today, Jay Edelson is testifying. They are going to get into cross examination and then take a break for lunch. So I'm hoping that by the time I am done here, I will be able to rejoin that hearing after their lunch break. I know I'm going to miss some cross, but I really, why are we doing things on Tuesday? It's coffee and curse words. I'm teasing. The federal court in Illinois gives two shits that it's Tuesday. But it's some really interesting stuff has come out, and we have so much to talk about, not just with that contempt hearing, but also the Elizabeth Holmes trial, a quick bits with Kim Kardashian, some Trillery stuff that's also going to be a quick bit today, and then a new ruling in the Tati Westbrook, Clark Swanson, James Westbrook Washington defamation case, with all of them personally suing and countersuing one another. So lots and lots to cover. Thank you for being here. Don't forget to do the YouTube things. We have binged. We're at like 186,000 on the road to 200K law nerds here, and it is so exciting. So thank you for being here. We should just get into all of it, because it's going to be a busy day. And I have to bounce on time today because I want to get back to that contempt hearing for sure and see what else we might learn. But what we've learned so far, y'all, there is some very interesting information coming out of this hearing, and I cannot wait to talk about it. So replay crew, love you. That'll be timestamped below when we're done, because I timestamp it not contemporaneous to streaming, because your girl can barely stream and think cohesively at the same time. So after the stream, should we get into it? You guys let me know where you're coming in from. We got lots of water here today on a Tuesday for me, and let's just get going. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. There is so much going on today. I feel like December, we have been running into all of the legal stuff, like just all of it. Before that, I did share on social media, and I have shared on the community tab here and stuff. We are in Middle Tennessee. We were not impacted directly, like our home, directly by the recent tornadoes. There are nearby communities that definitely had damage, but not as much as the damage in Kentucky. I'm going to leave links below if anyone is looking to donate. My family will also be doing that. It just devastating, unseasonable tornadoes. Not that it's ever easy when it's seasonable. It's just, it's hard. And then there's devastation, and then there's freezing temperatures. It just makes it very, very difficult. So I will be leaving those links below. I also put them in my community tab post, but it's one of those things that we, as newer transplants into Middle Tennessee, are not always used to. So thank you all for reaching out. To those of you in the text crew that I was able to chat with from Kentucky, thank you so much for chatting with me and responding. And I will always try to update when things like that happen, both on the community tab, Instagram, Twitter, and on the text crew. So for those of you that are in the text crew, if you're not, please feel free to join. Just textemily.com. If you hit that from your mobile, it'll just get you right into the text crew if you're in North America. But it was one of those things we definitely, it was a long night, Friday night, and we knew that on Friday Night Live. I'm like, okay, where are we at weather-wise? Like, we were keeping an eye on it Friday night. That ended up being very, very late Friday night, very early Friday morning that we took care of taking cover and stuff like that at our house. And then I did radio, the Times Radio London, very early Saturday morning, my time. So this weekend, I was not on social much. Occasionally I take downtimes off of social, particularly when I am tired. It is this time of year I am tired. So I'm always trying to be like, are we tired? Yes. Right now we're tired. We are tired. So Ashley, thank you so much. Mega catnip tip. I heard from Fred and George they were going to throw a real rager for New Year's. They're out running. I don't know where they are. I think they're sleeping. They are definitely not in the office. Thank you all for super chats. I'm trying to become a member, but I can't. The mods can help. You should be able to. It's hard to do from mobile devices if you are on an Apple mobile device because of Apple's rules. So it is hard to do from that, but you can do it. You can do it on desktop. So Friday night was a Monty Python craziness. Friday night was delightfully Monty Python. If you were here Friday night, you know. If you don't know what you don't know, it's a lot. Peter Mon, and probably someone else, but Peter Mon. And you'll have to just watch the replay with the chat. It's why I leave the chats live as much as I can. Sometimes if I have to do something with the video, blur something, edit something, sometimes I can't leave the chats live, and it's always such a bummer to me. So Adia said, just wanted to say, I love your content. As a kindergarten teacher, I am so busy, but watching you is my stress reliever and an opportunity for me time. I'm so glad. Thank you. If you guys see me looking at my phone, today is a lot. So I will be looking at my phone because there's also something that I am actively engaged in taking care of, that I need to be on my phone for, but we are here. We are live. I didn't want to cancel live because then I feel like all these topics just back up. And then when the topics back up, it's like, but now we're all backed up and like we have way too much to talk about. We'll never get to all of it. So we should just get into it. There was something I needed to, there was two things I needed to do. All right. Well, we're going to do them all right now. Let me see. Why is my Wi-Fi don't be weird, Wi-Fi. No, we don't. What we don't need is the Wi-Fi being weird. All right. This is why we timestamp everything. So the replay crew, can get directly to the topics or not. So let us do the things first. We're going to do quick bits first because I think that A, it's the easiest, and B, before I do that, I want to give a shout. We'll do shout outs in the quick bits. Rachel said, make sure you get B12 injections to help fatigue. Good to see you. Good to see you too, Rachel. I absolutely will. It is that time of the year. It is like December and it gets dark earlier and I just tired. And we've been covering so many stories that my brain is actually just tired from processing information. So we will be dealing with that over the holidays too. I will put out a holiday schedule. We're going to do a few less streams, but just a few less streams, but we will be doing that. Let's see. I just need to make sure I get this message and we're going to swoop into quick bits. So, just a quick thank you for your amazing coverage of so many cases. Makes my workday fly. Oh, I am so glad. Thank you so much for the super chat. It is appreciated. There are so many topics. It is all of the topics. So let us do the things. Quick bits. We're quick bitting. We are quick bitting. Emily, what are we doing? We're quick bits. We're time stamping them. And then we're quick bitsing. Oh, it's time. It's quick bits. All right, here's the thing. All right, we're going to the Twitters for quick bits. Our first quick bit story is about Kim Kardashian. Chat. I know people have strong feelings about Kim Kardashian. I get it. Everyone has their feelings, but we're going to talk about the law school journey. So with the law school journey, remember, we are talking about a human, even though they are a social media influencer that we might not all agree with. And I get it. You are welcome to your feelings, but we are keeping it classy in the chat. That's what we do. No matter who we talk about, we give everyone the same consideration. So I just ask that as we go here too, because at the end of the day, we are talking about a person. So Kim Kardashian West shared over the weekend or Friday or whenever. My brain is tired. So Kim Kardashian West, that I'm sure she will be changing her name back to Kim Kardashian because she made a motion to change her name back to Kim Kardashian because she is in the process of getting divorced and did file all of that with the court. But her post was, OMFG, I passed the baby bar exam. Looking in the mirror, I'm real proud of the woman looking back today in that reflection. I feel like this is first of all, my only critique is we could have probably done this better with the boom and sound crew, though I imagine they are filming for whatever show they are putting out because they ended Keeping Up with the Kardashians on but I think they've got a new show that they're in the middle of rolling. So that's what that is. For anyone who doesn't know my law school journey, no, this wasn't easy or handed to me. I'm sure that is the criticism, and I've received DMs from lots of you. Also, can we not with the tornadoes, Kim? Like look, December 13th, the tornadoes are ill-advised. I get the law books and the scales of justice, fantastic. The nerd glasses, fantastic. But maybe not the tornadoes. Maybe, you're not the only one. Jenny E is like, but maybe don't use the tornado emoji right now, given recent events. I mean, maybe just not. Okay, everyone is being triggered by the tornado emojis. I don't think it's sad to be triggered by a tornado emoji. I mean, there was a lot. It just is not particularly well thought. You could just leave those off. Like just a general, when you are a social media influencer, just a general awareness of things that are happening. I don't know if Kim Kardashian was aware of the devastating tornadoes that had hit because she lives in California. So, it would be like other people using fire emojis while California is on fire and Kim is evacuating their house. And they're all the fires in California are no joke, and they're terrifying, and they take people's homes and lives and livelihoods. Get it. But it would be the same as another influencer using that during that time and Kim being like, but we're evacuated from our house. It's fucking terrifying. Yes, that is how people feel. Just a general awareness, Kim. The tornado emojis weren't needed, but also that was an entire tweet with the emojis on December 13th. The timing, not great. She said, bottom line is don't ever give up when you are holding on by a thread. You can do it, set your mind to it and get it done because it feels so good once you're on the other side. I'm sure this is head to toe Balmain because Balmain seems to do the Blue Man Crew, stuff. That seems to be what they do with this seems to be them. I don't know. I don't watch fashion very much, but I know the Kardashians do a lot of Balmain, and this is the like head to toe Blue Man Crew bodysuit situation seems to be a signature of what they do. So what else did she say? What else? Pass the baby bar, blue. Bottom line is don't ever give up. We got all that. I think that's it. She said, Barbary law school, bar prep. I couldn't have done it without you guys setting me up with professors, Sam Farkas and Chuck Schultz. You changed my life. Thank you for putting in the hours, 10 hours a day, daily 4-hour Zooms, our in-person practice tests week after week. We did it. My dad would have been so proud. And he would actually be so shocked to know that this is my path now, but he would have been my best study partner. Not true. Actual lawyers practicing are not the best study partners because they forget all of the things and they can be a little hard on people. So I will absolutely break down the baby bar after we go through her tweets. I am told he was notorious for making fun of people who didn't pass on their first attempt like him. A lot of lawyers do that. I don't know if it necessarily, I don't know. Clowning on people because of test performance seems kind of stupid. But he would have been my best cheerleader, probably. And then the bottom line, don't ever give up when you are holding on by a thread. Look, I think Kim K has a lot of opportunities. A lot of people don't. That's for sure. She can pay for the tutoring. She can pay to have actual private tutors. A lot of people use Barbary, and a lot of people that are going to law school use student loans to pay for Barbary. However, I will say that Kim has shown that she wants to be a part of prison reform conversations. She wants to understand the criminal justice system, and she could do that without a law degree. She really could. I mean, she has the celebrity to get into any room that she wants to be in. She has actually gone to presidents of the United States to advocate for people to receive clemency. So she has the celebrity to actually effectuate change more than a lot of lawyers, no matter how good they are. a lot more than they have. So I think the fact that she wants to actually get the education to back up what she's trying to do is admirable. I do. I think that she didn't have to. I think that she could bring other lawyers around her and say, "You all help me understand it, and this is what I'm interested in doing," and not need the education to back it up. She's still the one who had to sit down and take this test. Yes, she has the money to get help. Yes, she has the money to get tutoring, but she still has to do the work and understand. She still does have kids. She has a lot more help than a lot of people do, but a lot of people take this journey on when they are single and in their 20s and can focus on themselves solely and have no other obligations, no other work obligations, no other commitments, no not filming a TV show. So I'm not going to clown on a celebrity wanting to be better informed when they are trying to be an advocate and make change. I'm just not going to. Yes, she has help, but I think that she's trying to use her celebrity for good. It feels like that scene in Clueless where Cher's like it's good to do stuff for other people when you're popular. Like that is a terrible misquote of Clueless, but it it kind of feels like Kim K is trying to use her wealth and her celebrity and her reach and her access to effectuate change that is important to her, and she's getting an education to back that up. So in California, you can become an attorney through almost an apprenticeship process where you don't have to have graduated from undergrad. Kim K um doesn't seem to have graduated from undergrad. Generally, you have to graduate from a four-year university to be accepted into an accredited law school. Once you're in an accredited law school, then you do not have to take the first year bar exam or the baby bar exam. When you have to take the baby bar exam is when you are either at a non-accredited school, which is why California lawyers can't just wave into other places, when you're in a non-accredited school, or when you are doing an apprenticeship track. Kim K is not in law school. She is apprenticing with other lawyers who are responsible and have signed up to teach her essentially the curriculum. So with that, you have to pass a first year exam. You have a certain amount of time to take it. And with taking that first year exam, you have to pass it before you can go on to your second and third years of study, before you can take the courses you need to take to sit for the bar exam. So this is the first step. So if you sit and take the test, you sit and take the test. This, I think, was her fourth go at it, which again, I think Kim K could have easily taken it the first two times and be like, that was hard. I tried. I'm out. Like, this is a lot of work, but has been continuing to try it. So while I know they lowered the pass rate for the California bar exam, I do not know if they changed the pass rate for the baby bar exam, because they are slightly different. So I know that Shane Simpson was able to get over the hurdle. Real Housewives of Orange County, Emily Simpson's husband, Shane Simpson, was finally able to pass the California bar exam after quite a number of takes, because they changed the standards due to COVID. I don't know if they changed the baby bar exam standards due to COVID, because Kim K took the baby bar exam during COVID, like the time 2 or 3 or 4 or all. So somebody in the chat, Ryan Lee's asking, is this comparable to the LSAT? It's much harder than the LSAT. The baby bar exam is more like very ramped up 1L exams that cover all of the foundational courses from your 1L. It is not an easy exam, because when you go when you go to an accredited school, there's a set course, there's a set curriculum, there's things like that. So this is to make sure that students have the foundation to go up. So the pass rate for the baby bar exam tends to be quite low. Like less than 30%, sometimes less than that. So it's a hurdle for sure. So we'll see if Kim K becomes Kim K ESQ. I don't think she's going to be putting a shingle out and saying, "Hey, come hire me as your lawyer." I really think this is that she wants, well, she said on the show, and I have seen clips where she has said she wants to have the foundational knowledge to continue doing the work that she's doing. So, all right. Good for her. Again, I think clowning her because she wants to do something other than just take pictures of her ass is maybe unfair to her. Hopefully it will um inspire others who maybe think that they can't go to law school. I mean, there were people I met in law school who had all kinds of diverse backgrounds, including working in strip clubs and other things before they came to law school and to afford to go to law school. I think diversity in the law is needed. It should be applauded. I don't think law should be gate kept behind well, you have to be like this, you have to be like that, you have to be able bodied, you have to be, not neurodivergent. You have to fit these molds. I think that that's a disservice to law. I think diverse viewpoints are needed. I think diverse experiences are needed. And I'm not going to clown on Kim K for that. I might clown Shane Simpson a little bit for not passing the bar as many times as he did. I mean, I might. Allison Rue said, I want my lawyer to be a former stripper. I mean, you never know. Diversity. D, don't you want to use your popularity for a good cause? Thank you, Brenda Lee Linden. Yes. Don't you want to use your popularity for a good cause? And I feel like, hopefully this expands Kim K's worldview a little bit. And she realizes things like why kimono as a branding tactic for Spanx, well, for a Spanx competitor, was a terrible idea. Like maybe a broader worldview and maybe some good. So the bar exam's fucking hard. I passed it on the first time. I'm just gonna put that out there. Just saying. But the bar exam is really fucking hard. And again, not gonna clown Kim K for that. So good for her. Whatever. Just be a lawyer. Great. Diversity. Exactly. Jordan, thank you. Exactly. If you know what, again, Jordan T, we will, there are more OnlyFans lawsuits going on. We will get back to them at another time. But yeah, it's just Kim K's Kim K. And I think that we need to stop gatekeeping professions. I just do. I think diversity in thought, particularly with law. I mean, I'm okay with surgeons being gatekept. Like you need the skills. You need the skills to be a lawyer. I think you should have to go to law school or at least prove competency. And that's what's being required with Kim K. She's going to have to prove competency with the baby bar and then the California bar exam. Go ahead. Learn what you need to learn. You can't fake that. You can't fake the bar exam. That's for sure. And I just don't think gatekeeping professions based on people's past is helpful. And I think what we need is more diversity in most of our professions. So yeah. So I'm not going to clown Kim K. I'm sure people will. She absolutely that exposition. She absolutely has advantages that most don't have going through law school, but I also think she probably has challenges that others don't have when going through law. I mean, most of it is most of it's that people I think don't understand what it takes to study, and that most law students are also having help supporting them. Not all, some are working for sure, some have kids for sure, but the average law student is more freshly out of college, generally doesn't have kids, and is able to focus 100% on it. And I don't think she's able to focus 100% on this as well. So, all right. So, okay, Kim K. Again, Kim K passed the baby bar. She shared it. She shared on TV that she hadn't passed. So, go her. If she doesn't pass the bar exam, I'm sure there will be people who are like, see, she couldn't do it. Lots of people don't pass the bar exam on the first time. I don't know the statistics. Somebody asked in the chat and I saw it ticking through how many people pass the California bar exam on the first try. I have no idea. So Danny Francis said, diversity in every career field is very beneficial. I agree with you. I think with law, with medicine, and with some others, the pathway to higher education is so expensive. And that can absolutely gatekeep. I think there are bigger conversations around there. I don't know what the fix to that conversation is, but there are definitely bigger conversations that need to happen. Didn't JFK take it like 6 times? Did he ever pass? I have no idea. There are lots who have not passed the California bar exam. I think Antonio Villaraigosa is one of them that took it like 5 plus times and didn't pass. But again, you would have to fact check me. All right. This is not where I want to be. Wrong window. All right. I need to figure out what we're talking about next because I don't want to forget. The Elizabeth Holmes trial. Let's talk about that real quick. I'm going to timestamp us. I'm going to swoop us and we're going to quick bit. That was a long quick bit about Kim K, but we're going to quick bit about Elizabeth Holmes real quick. So let us do that. The Elizabeth Holmes trial is over-ish. Over-ish. The Elizabeth Holmes trial, both sides have rested. The prosecution has rested. Oh, hold on. I need to see what they are saying about my car. Let's see. Nope. All right. The prosecution has rested. The defense has rested. The prosecution didn't bring rebuttal witnesses, which means the last witness testimony that was heard by the jury is the testimony of Elizabeth Holmes. Elizabeth Holmes' testimony was exceedingly long, days long. Her cross-examination was days long. And with that, they brought out on cross-examination that her memory wasn't quite as crisp as it was on direct examination. There was a lot of exposition in her answers, like, I don't quite remember saying this. I don't quite remember saying that. I'm not sure that I said that. There was a lot of hedging where her answers on direct were very direct. They absolutely got into things like her relationship with Sunny Balwani, who had been her boyfriend and her COO. She put out there that they had had a tumultuous and abusive relationship. The prosecution, I think, was respectful of that testimony on direct while also doing their job on cross and really bringing up that even though she said she had this relationship with Balwani, that she was the one who ended the relationship. She was the one who fired him. They brought up thousands of text messages. She didn't read them all in, but text messages also showing a loving and committed relationship. They also brought up something I didn't know, that she had also had another years-long relationship going on while she was in a relationship with Sunny Balwani, which is very interesting to me, that it seemed on direct, her testimony was almost, I just did what everyone told me to do because my partner was very domineering. And then the prosecution's like, but also you had a side piece for years. So how domineering was your relationship when you also were in another relationship? Just why? So with that, it was really interesting to me to see that you had this difference. And I had never heard it anywhere that she was having another relationship during the time she was with Sunny Balwani. I was like, wait, what? So I think that it'll be very interesting to see how the jury parses that. I also think that it was very from the reports, of course, the court is not live streaming or anything like that. But with that, the reports that this testimony was elicited on cross, it sounds like the prosecution did this in a tactful way, but also cutting to the heart of her story of, were you really so domineered by this relationship that you were isolated from friends and family, that you had to spend every minute with Sunny, that you felt that this was a harmful and abusive relationship to you? But also, if that is the case, then how did you have a years long other romantic relationship at the same time? So there's that. That was new testimony to me. She also admitted that she had modified a number of the documents that were key documents in this trial. And in saying that she had modified some of these documents, I wonder if those things will go a long way with the jury. I think on direct, the the attorneys did a very good job of letting Elizabeth tell her story and build her as a human to the jury. And she was tremendously young when she started this company, and I think they leaned into that a bit. But then on cross examination, I think the prosecution did a great job of reminding the jurors of the months of testimony that have taken place. And again, using Elizabeth Holmes's words against her in playing clips of other statements, clips of depositions to the SEC, clips of statements to um, reporters and in media outlets. And I anticipate that they will do that in closing as well. Closing arguments won't be until the 20th. I don't know if this will benefit the defense or hurt the defense. It is my general impression that this could be difficult for the defense because you've gotten further away from the humanizing of Elizabeth Holmes and further away from the testimony where she was crying over her relationship and talking about how she just earnestly believed the people around her. And you get further away from that and are left with the, cross examination saying that she doctored and changed these important documents that went to investors, that she all of a sudden can't understand these questions and can't remember these things. And um I think that in closing, which will start Thursday and Friday, I think that in closing this case, the prosecution will lean heavily on Elizabeth's own words. I don't know if the jury will think that her relationship with Sunny Balwani made it so that she could not run her company, because at the end of the day, she fired him and she broke up with him. So is that someone that's so domineering to her that she couldn't make her own choices in her own company? I don't know if the jury will find that, or if they will find that she willfully and intentionally misled investors. Her admitting to editing some of the documents that went to investors is a big deal. Her admitting that she didn't remember that she sent the Fortune article that was such a big deal out to investors and never corrected statements in that article, even though she's admitted to them being false, I think will very much play against her. And I will not be surprised if the jury convicts her. I think the prosecution has done a very good job of kind of picking apart her defense without being dicks about it. Just to put it completely bluntly, because there's a way to do that and there's a way not to do that, especially when the defendant is saying that they were manipulated by outside forces. So I think that the jury can convict her. I think there's definitely enough evidence to. If they don't, then the defense may have worked, where the jury thinks that she believed in her heart of hearts that what she was being told was true. I think that the cross-examination of her went to prove that she knew things she was saying weren't true. And that's really the crux of the whole thing. She said over and over, "I wish I had done things differently." The prosecution really kept bringing that up. I'm sure it'll be a theme in closing. Elizabeth wishes she had done things differently now, but she didn't. She wishes she had done things differently now, but she didn't. And those things are criminal. And those things are willfully misleading. And she defrauded investors because she was out of time and out of money and had to do what she had to do. And I think that's what it was. So that's what we're doing. Let us continue on. We're going to talk about Triller next, and then we are going to go to the contempt hearing and to Tati. So let's move on to some Trillery stuff, because there was a court ruling. Oh, I need to pull up. You know what? I'm going to swoop and then I'll pull up and then we'll do the things. Let's talk about Triller and Ethan Klein and the things. Let me timestamp this. Me looking back and forth so I can like write and like this is why I can't have a ponytail. Like that's why we can't have nice things. This is why we can't have nice things. All right. Triller, Ethan Klein, H3H3. There is a new ruling in that case. We are going to talk about it. There are multiple cases here. So just as a road so far, Triller sued a whole bunch of people in federal court over the Ben Askren, Jake Paul fight. If I mistake which Paul brother it is, sometimes I do that in my head. They blend together. That's just because that happens. But Ben Askren, Jake Paul fight. Most of those cases have been yeeted out of court, but not all. We went through in great length the amazing and sassy Judge Anderson in the Central District there of California, Judge Anderson, saying, this is not even okay. What are you doing? Misjoinder. Yeet. It was great. I just, simpler times. I wish, can we just go back to Judge Anderson yeeting people? Please. After that, Triller, after multiple maturations, they sued H3 in that, all the defendants. So that was the first. Triller sued H3 with Mike, and everybody else. Film Daily, all the people. That case has since been thrown out for failure to prosecute. They've never served Film Daily. I don't think they know who's behind the company. Film Daily, eat. Case number one. Case number two, Triller sued the H3 podcast, their production company et al., under a federal lawsuit for the copyright causes of action, saying that they believe that the fight was pirated, et cetera, et cetera. That is the federal cause of action. Then Triller sued the production company Ted Entertainment, Ethan Klein, Ela Klein, Teddy Fresh et al. I refer to it as H3 because we're just going to consolidate, but it technically is their production company, all the moving pieces in California over the alleged brigading of the App Store and Google Play Store reviews. So saying that it was an interference with business, that the mean things were said about Ryan Kavanaugh, and that the app ratings were prompted by Ethan Klein. This is the one that deals with the Reddit thread posts and the foot soldiers going to war and all of this stuff. That is in California court in Los Angeles. So copyright in federal court, the App Store ratings in Los Angeles Superior Court. Ethan Klein's team filed a anti-slap motion, and that's the posture that case is in. Then, so that's 3 cases. The first one's gone, second federal one, and then the California one. Then the 4th case was filed, which was Ryan Kavanaugh personally suing Ethan Klein over the statement that Ethan is alleged to have said, well, I don't even know if I need to say alleged because I've seen videos. Ethan has said, I don't know if we need to say alleged. Ethan has said that Ryan Kavanaugh was accused by his business partner of running a Ponzi scheme. Ryan Kavanaugh says that is allegedly defamatory. I have a lot of thoughts about that, but we're not on that lawsuit just yet. So we're talking about the California lawsuit with regard to the App Store and hurt feelings over Reddit, even though Triller's a company and can't have hurt feelings, but either way. I need to check the LA Superior Court website. I meant to do it before we went live, and then I got very engrossed in the contempt hearing that's going on in the Girardi case. So let me pull this up and see. We're just going to pull it all up together. All right. Let me make sure I don't have to type in my password, which I don't. Okay, let's pull up this court ruling. Slap motions, anti-slap motions, we've talked about a lot. I'm not going to get into it in depth today, but SLAP stands for Strategic Litigation Against Public Participation. I probably didn't even match those up. Same. Strategic litigation against public participation. The strategic litigation against public participation generally in most jurisdictions applies to spoken words, news reporting, book publishing, these types of things. In some jurisdictions, it's a little quirkier. California has a very strong SLAPP statute, and you can file an anti-SLAPP motion saying, you are trying to shut me up. Your case has no merit. If I file a SLAPP motion and win, defendant files a SLAPP motion and wins, the case is dismissed with prejudice. It cannot be refiled, and the party that filed it has to generally pay attorney's fees and costs for the party that won. That is what's going on right now in the LA Superior Court with regard to Triller suing H3 et al. Over the App Store alleged interference with business, et cetera, et cetera. Now, it seemed from the hearing, and the transcript was attached, it seemed from the hearing that we went over that the court was very much inclined to grant Ethan Klein's motion and dismiss the case with prejudice. But the court took motions on whether the court should allow additional briefing. Hey, you can tell me more shit. Prove to me, plaintiff, Triller, prove to me how you're directly damaged. Prove to me how this is how you stand to win on the merits. Because the court's like, I'm not seeing it. Like, if your shit was flipped, couldn't somebody leave you a 1-star review in the App Store? And how is that directly hurting your business? And how is Ethan Klein involved in anything other than their own review of the App Store, which is seen to be hyperbole? So how are we getting here? Please enlighten me. So the court made a ruling on whether they would allow additional briefing. And here's what the court said. I know that was a lot of a road so far. Y'all are like, I'm exhausted. Yes, it's exhausting. All of this has been exhausting. And I need to answer this message. So I'm going to answer this message as we get into reading this all together. Let me see. Thrilling, isn't it? All right. Yay, things are done that needed to get done. Okay. The court said, nature of the proceedings, court order regarding additional briefing. This was filed. I briefly touched on it, but we were so busy with the other trials going on, we didn't get to talk about it a lot. Nature of the proceedings, the court has considered the parties' briefing regarding the propriety of granting plaintiff Triller's request at oral argument to submit late evidence in support of its opposition. This is the opposition to the SLAPP motion, the anti-SLAPP motion. If Triller loses this motion, this case is done and they have to pay lawyers' fees for Ethan Klein. The court has also considered the November 9th arguments of counsel and plaintiff's counsel offer of proof. In the interest of fully adjudicating matters, I think this means that the court is inclined to grant this and is trying to say, look, put it all out there. Put everything out there. Give me everything that you've got so I can decide if I'm going to yeet this or not. In the interest of fully adjudicating matters on the merits and in consideration that the grant of an anti-SLAPP motion terminates the litigation at the trial court, this court will permit further evidence and briefings as follows. Plaintiff's supplemental brief and evidence not to exceed 10 pages, we'll talk about that in a minute, is to be filed and served on or before December 7th. What's to date? Oh, today's the 14th. So we're 7 days out from this. Keep that in mind. Defendant's responsive brief, not to exceed 10 pages, is to be filed and served on or before December 14th, 2021. No further filings or requests will be considered by the court. So, defense, file by December 7th, or plaintiff, file by December 7th, plaintiff Triller. Defense, Ethan Klein et al., file by December 14th. No further filings or requests. After that, the court is ruling. On the court's own motion, the hearing on the special motion to strike, which is the anti-SLAPP motion, is scheduled for 12/13, is advanced on this date. So it means the court is moving the court date up to December 2nd and then continuing it, is advanced and continued to January 11th, 2022 at 8:30 a.m. So January 11th is the next date we need to remember. January 11th being the day that the court will consider this additional briefing. Here's the thing. When I go to this court's Triller versus TED Entertainment, there is no filing. The last filing is that order from December 7th. It's been a week. Where is Triller's filing? Where? Triller, where is your filing? It's been a week. Now, sometimes things take a couple days to populate. And there's been times I'm like, Triller didn't file this. And then a day later, it's like, oh, here it is. But it's now been a week. So where is the filing? And what are they relying on? Because on December 2nd, the same day that this order was granted, Triller filed a declaration and a substitute memorandum of points and authorities, but those motions were going toward the courts asking for briefing regarding granting this motion. So the court said, hey, tell me why I should allow you to file more. So the last filings from Triller were, tell me why I should let you file more. But the court said you need to file by the 7th. And though I've seen the court take time to upload, it's been a week. So I don't know if Triller filed or not. It's not showing up. It's been a week. Normally we see these things filed sooner. I don't know if Triller is trying to rely on their last declaration, but look at this declaration. Let's just. This is the declaration filed from December 2nd. 819 pages. The responsive briefing is 76 pages. I imagine this briefing, a lot of those pages were the transcript. But 76 pages? 819 pages? What is this? Just another flowchart of app responses? I'm going to bite the bullet and just download these. By the way, California does not make it cheap to download documents. I'm absolutely going to download these documents. I just haven't wanted to yet because I'm like, oh, fucking hell. I will do that before Friday. We will talk about this more on Friday. But it's been a week. And there is no there's nothing. I've not seen it take this long. So where is Triller's filing that was due per the court's order on December 7th? Where is it? Where is it? Where is it? I don't know. I don't know either. So we'll see what they do. The thing that I wonder, and we're going to talk about it. I'm not going to swoop, but I will make a time note. We're going to talk about the Kavanaugh case just a little bit. With the Kavanaugh case, here's what I wonder. If Triller saw that they were losing this case, which based on the transcript, it's my opinion, based on reading that transcript, that the court was inclined and is inclined to grant the anti-SLAPP motion. The court would not have issued this ruling if the court was not leaning towards granting the anti-SLAPP. The court says it in here. I see this as signaling. This is my interpretation of what the court said. In the interest of fully adjudicating matters on the merits and in consideration that the grant of an anti-SLAPP motion terminates the litigation at the trial court. If the court was inclined to just deny the motion, the court wouldn't have entertained additional briefing because it wouldn't have fucking mattered. The court would have been like, motion denied, move on towards litigation. There's no reason. The court is trying to give Triller the space to show them what they need to see so that when the court grants this motion and terminates litigation, they've considered everything because it is a very strong remedy. That's the point, and why some don't like anti-SLAPP statutes. It is a very strong remedy, very, very early on in the proceedings, but it's supposed to limit harassment by lawsuit. And if they lose, they have to pay Ethan Klein. Can you imagine what will happen on the H3 podcast when Triller has to send a check to Ethan Klein for lawyers' fees for this? Because Ethan's lawyers will have had to read 800 pages of whatever the fuck they filed. So, based on the way that the court ordered this, and based on the fact that the court isn't going to bother accepting additional briefing if they're not going to grant the motion, then I think that the court is likely to grant this and dismiss this case. That being true, in my mind, then when Ethan got sued by Ryan Kavanaugh, does that mean that Kavanaugh is trying to bring the same claims? Me talking out loud. Kavanaugh trying to bring the same claims that are at the heart of this litigation because they see that the Triller one is losing. So now they're just trying to bring litigation personally for the same kind of cause of action. And they are not the exact same causes of action, but it is the same underlying thing being Ethan Klein talking shit on Ryan Kavanaugh on the internet, because it's the internet. That's the underlying cause of action of both of these. So would that bolster, should Ethan and his lawyers choose to pursue whether this is using litigation as a form of harassment or whether this is vexatious litigation, should they choose to pursue that, does this motion give more grounds to that or not? I don't know. I think it's possible. I think it's possible that seeing the writing on the wall and then filing another suit maybe would indicate to a court that this is just trying to shut Ethan Klein up. Now, when we talk about the Triller lawsuit, and I did the initial reading of it, you know how I feel about it. I think that it is, I think that it's much better written than the other Triller suits. They brought in other legal counsel. But I have gone through that filing a few times. I have talked to other attorneys about it. I have considered it. I don't see a route to success for Ryan Kavanaugh because at the end of the day, what Ethan is alleged to have said, that I think in all of the videos, and I haven't gone through and watched them all, in the videos that I have seen, what Ethan has said is Ryan Kavanaugh was accused by a prior business partner of running a Ponzi scheme. It seems that it's all been coalesced in that. And the complaint says that. And the complaint very much says in the headers, Ethan Klein accuses Ryan Kavanaugh of running a Ponzi scheme. But when you actually look at the heart of the statements, that's not what happens. In the heart of the statements in the lawsuit, it says Ethan Klein says Ryan Kavanaugh is alleged to have run a Ponzi scheme by an ex-business partner. That fair reporting is going to take over because, again, that's been reported. The Variety article is still up. The Variety article still has a unfiled but signed under penalty of perjury legal document that still says that. When we pulled it up together, when we covered that lawsuit, there was whiskey involved, but we pulled it up together and read it together. It says that in there. And so even though the parties settled, and even though the statement might have been retracted, it doesn't mean that it wasn't alleged. Like, it doesn't undo it. So it doesn't undo the allegation. So then you don't really get past the first part of defamation because it has to be untrue. And how is it untrue if the allegation was in fact made? Even if it was subsequently retracted, it was still made. So I just don't think that, other than trying to cost Ethan Klein a bunch of money and headache and trying to drag him through the mud and then make quips about his beef with Keemstar, I don't see him losing that lawsuit. I mean, he could absolutely choose to settle. He could absolutely choose to say, "Fuck you, we ride." Like, family forever, foot soldiers unite. Here we go. But it seems that um Kavanaugh is the type of plaintiff that has the money to see this out to the end. It also seems that Ethan Klein is like, I'm not wrong, motherfuckers. So what I'm not going to do is back down and we're done. Um, I think Ryan Kavanaugh maybe underestimated what it means to have a community, and I also think that even on YouTube, there are plenty that don't like Ethan Klein. I think Ethan, separate and apart from this, if you just view Ethan as a content creator, this is not good for content creators if Kavanaugh wins, because a lot of what content creators do is fair reporting. When content creators don't report fairly, then it's fair to say, look, this court document does not say that. If Ethan had read into that article and assumed and extrapolated and added in details that weren't in there, then maybe it's a problem. But he's retelling what was in there, and retelling what was in there is fair reporting. You're allowed to say what lawsuits say. That's what creators do. Um, and it is fair that that's what creators do. You are allowed to read court documents. What you're not allowed to do is read a court document and go, oh, and it says this and this and this, if those things aren't an accurate representation of what was said. So I think it is important to understand that this has larger ramifications than just Ethan and Ryan Kavanaugh. This has potential implications for the creator community, for the commentary community, and even for the types of things that I do. But also, I don't like our court system being used like a football where people who have money can just try to silence other people. And it seems that that is what Kavanaugh is trying to do. I have enough money to make you shut the fuck up. I don't like what you've said about me, so I'm going to use the litigation process in an improper way. That's not to say that I think all defamation suits are bullshit. I don't. If someone is defaming someone and causing them reputational damage and financial damage, they should be able to pursue the remedy. I don't like that our system has become the thou with the most money can prevail. And unfortunately, that's a lot of what our civil litigation system is right now. And the anti-SLAPP motion is trying to remedy that, trying to end this type of litigation that doesn't stand a chance on the merits early on. So I think there's a lot of a lot of importance to this suit that goes well beyond Kavanaugh and Klein. It goes to creators and independent media versus those who don't like what's being said about them. And people are allowed to be dicks on the internet. That's fact. You're allowed to be mean. I don't love it. You know that I don't, that's not the way I want to do shit on the internet. But also, you're allowed to say mean things to people. There are mean things that aren't defamatory. Ethan Klein saying that he'd rather get like a colonoscopy by a chain link fence than use the Triller app is mean, but it's not defamatory. It's hyperbole. And comedy is allowed to be mean, even if you don't find it's funny, even if you think it's the most offensive shit you've ever heard. If it's not defamatory, it's allowed to be said. And we're at a place where there's this push pull between actual free speech, which is easy to stand by when it's not offensive. It's easy to stand by when it's not mean. And it's harder to stand by when you're like, yeah, but I fucking hate that's what you're saying. But the actual free speech and actual, you know, open discourse versus those with money who can try to shut it down because they don't like what's being said. So it will be interesting to see what happens, both with the anti-SLAPP motion. And I think the judge asked a lot of very valid questions when it comes to the Triller app. It's like, right, but are there reasons that app users might leave these reviews other than just brigading? So that is where we're at. It is. So mean does not always equal defamatory. And Ryan Kavanaugh doesn't like what's being said, but also Ryan Kavanaugh maybe should have sued Variety. The Variety article is still up. It still has an attachment of the lawsuit where the business partner made the allegations and signed it under penalty of perjury. It would be interesting if during discovery for me, um, it will be interesting to see if this gets into discovery, if Ethan Klein's legal team asks for the settlement agreement between Kavanaugh and his ex-business partner. Because if the settlement agreement demands a retraction, then it doesn't mean the statement was never true. It means that the statement was retracted due to a settlement agreement, which is not uncommon at all. And but that doesn't that then repeating the statement and saying that it was alleged by this other person isn't defamatory because it's protected by being true. The allegation was made. It was just later retracted because of a settlement agreement. But it was also signed under penalty of perjury. So if this gets to discovery, it'll be interesting to see if we see that. I don't know if this case will get to discovery. I'm sure there will either be a motion to dismiss or an anti-slap motion made in this case too. It'll be interesting to see what happens here. I think if Ethan didn't have the community he has, didn't have other businesses, and didn't have the financial, most people in the face of this would have just said fuck it and back down. And would have just said, I retract. I want no piece of this. I do not have the money to deal with this. I do not want to deal with it. I'm just, yep, we're done. We're never going to say that again. But that's not what's going to happen here. And I think at the end of the day, we're going to end up with lawsuits that we are talking about for quite a while about the boundaries of what is and is not said on the internet, about who's responsible for what's said on the internet, about what the difference between a independent broadcaster is. Like, why is Variety more protected and not sued than Ethan Klein? Ethan Klein's an independent media creator. So why sue him and not Variety? Is it because it's perceived that he has less money? So we'll see. I'm going to keep covering it. I know you guys want to keep covering it. I'm going to be literally looking daily and sometimes multiple times a day to see if Triller's response pops up, because right now there is nothing, and that was due 7 days ago. And if it's not filed, is the court just going to be like, well, you didn't respond, so yeet? We'll see. I'm fascinated. Hopefully you're fascinated. One of the reasons I keep talking about this is because it is a bigger conversation about speech, about comedy. And there's a difference between what a company might choose to step away from a creator for. And a company would be like, you can't say that on our platform. We don't agree with this type of statement. Our platform is not allowing that kind of speech. But that's a different threshold than what somebody can be sued for. Sometimes they overlap, sometimes they don't. But we're getting into a place where between Section 230 and platforms as publishers or not as publishers or as common carriers, and people who want to say shit that a lot of us are going to find offensive, where those boundaries are and where private companies meet public square, and speech is going through an interesting growth period. And I think the law with regard to protected speech is going to be going through an interesting growth period as it relates to the internet. So buckle up. There's going to be a lot that comes in the realm of speech, and we will see what happens. It's going to be interesting to follow the law on this, on what really is a pissing match because somebody's feelings got hurt about what was said about them on a podcast. But it can become a very important issue for creators and independent media. So here we go. Here we go with the Kavanaugh Ethan Klein. And yep. So that's where we're at with that. We're all gonna wait and see if Triller files a response, and when they do, we'll cover it. Maybe we're gonna cover it on Friday. Who knows? Who knows if it'll be filed by then? I don't know. Should we talk about this contempt hearing? Are you guys ready to talk about contempt hearings? Because shit happened. Like, it's going down. And then we're going to talk about Tati. Also, shit happens. That's another court hearing. Should we do that first? No, let's do the contempt hearing and then we'll do Tati. And then we'll do questions. No, I reverse myself. Let's do Tati first and then contempt. And then questions. Because I'm sure y'all have a bunch of them. Because the contempt hearing is going to probably lead to more questions that, yeah, I imagine. Tati, contempt, Q&A. That's the plan. You're watching it happen live. I have not been following the Ace family eviction. I know that attorney Tom recently covered it. He did a really good video on it. I have not been keeping up with the Ace family. I haven't. I don't. Oh, not that. You're not talking about that. You're talking about the other ones. No, that is on my list to swing back around to see what's going on with the lawsuits over the fight. That I'm very much interested in. I have not pulled that back up because other things have been moving so fast. But yes, the fight lawsuits I will be swinging back around for, and Catherine and the makeup line lawsuits. I'm not going to cover the eviction stuff at this point. So let us continue on. And then we will get to, what did I say? We're going to talk about Tati and Swanson, and then we're going to get to contempt hearings. So let me pull up my files and then we will swoop. And I will do, let's see. I'm just going to do the order first. I'm going to do a road so far and then the order. I think that's fair. No. Yes. Emily, decide. No. A lot of information has come into my brain today. We're going to do the order first and then we'll go from there. That's what we're doing. In talking about multi-pronged lawsuits, we cannot leave out the Tati Westbrook lawsuits. This started as one, and now it has like spokes, like a wheel or an asterisk. Maybe it's just an asterisk of lawsuits. It's like the one little nucleus and then all of the different pieces. But what started as the business partner lawsuit filed by Clark Swanson as a derivative lawsuit in Los Angeles against Halo Beauty and Tati Westbrook et al. It started with this is a lawsuit because of the defendant's greed. And the story was broken and the internet ran with it. We were all like, this is fascinating. And all the names were in it, beauty influencers and Sugar Bear Hair and the bi sister of it all. That was over a year ago now. That case is now being moved into probably Nevada, but the court has dismissed it for form nonconvenience. So it's going to have to move to another jurisdiction. I imagine it's moving to Nevada. I haven't seen that happen. Things are going to happen. That's going to move. It's not like 100% yeeted. It's just yeeted to another location. Then there was the Tati Westbrook KJ without a crystal ball defamation suit that settled. The settlement of that suit seemed to point to the source that was being relied on was Clark Swanson. Clark Swanson has denied the bulk of that. That suit was filed and then dismissed for jurisdiction and then settled instead of being refiled in Minnesota. Then the Nevada lawsuit was filed. And in the Nevada lawsuit, Tati et al. Sued Swanson. We haven't gotten back to that. We need to loop back to that one. Quite a lot went down at the beginning and they were fighting over the books. We learned that Swanson had been fired. It was just so much happening. The defamation suit from Washington came back up again. And it was, this person is speaking to that, Swanson was speaking to a YouTuber and that YouTuber like put all this stuff on the internet. And it was like, all of those allegations were made. Allegations were denied. There's been multiple declarations filed in that case. And the court was like, turn over the documents. We're moving forward. Then Swanson, he might have actually filed this one first, but in the order I've covered them in, Swanson filed the defamation suit personally in Washington. And that is Clark Swanson versus Tati and James Westbrook and John and Jane Doe. That was filed in June. We didn't start covering it until it became public record, which was sometime later. And That case is moving its way through court. We covered the answer and counterclaims. The answer and counterclaims made, first of all, they answered, there was lots of sass in the answer. And then counterclaims Tati and James made against Clark Swanson. So now Clark Swanson is suing Tati and James. Tati and James are suing Clark Swanson. We are now in like a Gordian knot of lawsuits, snake eating its tail situation going on up in Washington. Swanson filed a motion to strike parts of the counterclaim, saying, look, you can't make these allegations in this lawsuit. And the allegations they took issue with were that the allegation that Swanson had acted inappropriately and unprofessionally towards Tati and had inappropriately touched her. And then they are saying that they are minimizing the damage to Swanson's reputation by not diving into that further. Then Tati and James Westbrook responded. We covered that, I think, last week. So much has happened in the last 2 weeks. That is in the playlist of this case. That was covered, I think it was last week. There's a declaration from Tati. They are alleging the foot rubbing and shoulder touching of it all. There was a declaration from Tati's assistant, and it dove much more into detail about the allegations that they made. And then they also said, look, these parts of the complaint can't be stricken because the inappropriate conduct, again, this is in their filings, the inappropriate conduct and unwanted physical touching of Tati Westbrook are true. They go into her declaration, and then they say Swanson put it at issue because Swanson included the fuchs. Fucks. What does the fuck say? The fucks letter, the fuchs letter. We're going with fucks. Fuchs. That we just can't not. Because then we can make the salty fucks jokes, and it's just it humors me. So the Fuchs letter was attached to Swanson's complaint and First Amendment complaint. So the argument was, you attached the letter. The letter made these allegations. This is all already part of the record. Then what we haven't gone over yet is the reply from Clark Swanson replying saying, no, you can't just say shit. So this is the reply from Swanson plaintiff saying, hey, this is a pattern where James and Tati are continuing to defame and disparage Swanson in every possible public forum, and when challenged, appoint themselves the arbiters of truth. So Swanson is like, no. What you're not going to do is continue to say this. I will say it is my opinion, has been my opinion, and remains my opinion that Swanson kind of tipped this off when filing his lawsuit full of allegations and shade in Los Angeles, a lawsuit that his lawyer hadn't even signed. That was like Tati said, or alleged that Tati said that she could sell whatever shit she wanted to her fans and they would buy it, and that they're greedy and that they swindled him and all of that stuff. So allegations and shade. So I'm not surprised that the allegations and shade have been met with allegations and shade. At the end of the day, I think everyone is going to walk away from this with a lot less money and very bad feelings towards each other. But that is just how I see it. So lots and lots of allegations and shade. Remember, lawsuits aren't just that. So they say that the Westbrooks have asserted counterclaims against Swanson based on an allegedly illegal recording of a conversation and a separate lawsuit in California. Those are the only counterclaims asserted. The factual allegations for the counterclaims: the Westbrooks allege that Swanson engaged in inappropriate touching and unprofessional conduct. However, I think that narrowly states the issue, but the rest of the issue was also, this went on. This was from the previous filing. That's what Tati and James were saying. This went on, well, through their lawyers. This went on, and we told him this went on, and we told him we were going to step away from day-to-day operations. And then he initiated litigation against us. So it was context, which was that's how I took it when I was reading these documents, as context. They're taking it as extra shade to try to destroy Swanson's reputation, because They are allowed to frame this how they want to frame it. Adversarial proceedings. They say that the Westbrooks offered no valid basis for including these allegations in their counterclaims. The only purpose for the Westbrooks allegations is to scandalize. So to make it sensational. Remember, we started with this is a lawsuit based on the defendant's greed. No, we don't need you defining scandalize. So it started with this is a lawsuit based on the defendant's greed. So if anybody pulled the pin and lobbed a grenade, I think Swanson kind of started it. But also, the Fuchs letter that we covered and that's attached to Swanson's lawsuit was their back and forth behind the scenes. So they all knew going in what was going to come out because Tati's lawyers told Swanson lawyers, yeah, well, this. So they all knew what was eventually going to play out on the court if they went to court. I'm just saying, if you don't start hurling grenades at each other, maybe you don't end up with all of the allegations and shade. Just my opinion. He goes on to say that the Westbrooks' opposition is flawed in several respects, that it is an apparent attempt to mislead the court. Don't talk down to the court. The court does not want to be misled, but the court might see if they are being misled. That the Westbrooks repeatedly characterize their improper touching allegations as being set forth in paragraphs 2 through 4, which we've covered a few times and we're not going to repeat, of their answer to support their assertion that the allegations should not be stricken because they relate to their affirmative defenses to Swanson's complaint. I think that is a fair statement. They do relate to the affirmative defenses. Opposition at 1, 3, 4, 5, 6. A plain review of the pleadings, however, reveals that paragraphs 2 through 4 of the complaint and the answer describe the parties to the lawsuit and do not contain anything remotely related to the improper touching allegations. Well, background though. Swanson's motion to strike requests that the court strike counterclaims paragraph 2 through 4, not answer paragraph 2 through 4. Second, while the Westbrooks suggest the allegations are related to their defenses, their answer already adequately addresses their defenses. Well, you don't get to decide if it's adequate. You're opposing counsel. You don't get to decide. The Westbrook answer denies that a letter sent by their counsel and attached to the operative complaint is littered with untruthful statements. Footnote 1. This letter was included with the filings, quote, to give notice to the court and the opponent of the general nature of the claims asserted. But it's still part of the record. It doesn't make it less part of the record. And the answers state their defense. Plaintiff's claims are barred in whole or in part because the statements referenced in the fact that form the basis of the plaintiff's claims are true. The Westbrooks have no good faith reason for repeating the letter's allegations in their counterclaims. Third, they say that the Westbrooks state that their allegations should not be stricken because, quote, the facts at issue are true. The Westbrooks seem to suggest that the existence of a legal rule that before a court may strike matters under Civil Rule 12F, the court must engage in fact-finding to determine if any of the allegations are true. This is an incorrect statement of the law and the court's duty. The claimed truth of the allegations has no bearing on whether the allegations are immaterial or impertinent. So they're saying even if it's true, it can still be irrelevant. Finally, they say the Westbrooks make absolutely no argument for why the improper touching allegations are relevant to their counterclaims, nor could they do so. The counterclaims only assert claims arising from the alleged improper recording of a business meeting and the filing of a California lawsuit, though they do say that the filing of the California lawsuit was because they were going to remove him from the company, and they were going to remove him from the company because of these things, but okay. The improper touching allegations have no bearing on these claims. Their sole purpose in the counterclaim is to raise immaterial, impertinent, and scandalous matters in their public court filings to continue their campaign against Mr. Swanson. Mr. Swanson has requested that the Westbrooks agree to refrain. Wait a sec. Okay. I lost myself mid-sentence. Mr. Swanson has requested that the Westbrooks agree to refrain from making public statements about this litigation. See declaration. Counsel for the Westbrooks has stated that they are not interested in stipulating to refraining from speaking about the case. Given Ms. Westbrook's YouTube status, it is more than reasonable to assume that pleadings filed in this case will end up being broadcast on the internet. Hi, we broadcast things on the internet. making the Westbrooks' inclusion of the improper touching allegations in their counterclaims all the more concerning. I feel like the rewriting of history in all of this is concerning for me and for the internet. So, internet, let us all see if we remember this right. If I am not chat replay crew, if I am not remembering this accurately, will you please remind a girl? But as I recall, the allegations in this lawsuit say, not this one, but in the all, you had the business partner lawsuit that contained allegations against Tati, that Tati was greedy, that the lawsuit was because of her greed, that they did not have great business acumen, that they were essentially nothing without Swanson, that Tati was saying that behind the scenes she could sell whatever shit to her audience, and made quite a lot of statements about Tati. And then it's alleged in the Nevada lawsuit that Swanson took that lawsuit and planted it with YouTubers that they knew or should have known would run with it and break the story. That the breaking of the story then became a massive story that garnered international attention, as was said in this lawsuit and the other lawsuit, that this lawsuit garnered international news attention because, well, of the salacious allegations that were contained within that lawsuit, the business partner lawsuit, the first lawsuit. So if this got blown up into the public sphere, is it because Tati has a YouTube channel? Or, well, maybe, but is it also because of the allegations in the Nevada suit that Swanson told people to break the story of this lawsuit? Who's on first here? So now they're concerned. Now Swanson's lawyers are concerned. Now we're concerned. But the reason it started getting covered in international news media is because the story got broken by someone. And the story got broken because Swanson told them about the story. So the shit's already out of the horse. And the reason the shit's already out of the horse seems to be because of Swanson, based on all of the allegations. That seems to be what happened there, based on those allegations. That eventually, yes, the media may have picked up that business partner lawsuit. That might have actually happened. But it seems that was hastened by the story being given to someone, told to someone, asked to be broken by someone based on that someone's statements. So if you are saying, I've sued someone, here it is, cover it, then you're the one hastening it onto the internet, in my opinion. So Swanson denies those allegations. But based on the Nevada suit, based on the video regarding the settlement of the Westbrook KJ suit, that's what's been alleged. So this shit was out of the horse before this lawsuit even got filed. So they're like, we don't want it to be on the internet. Well, who put it on the internet to begin with? We all just are along for the ride now. Again, Swanson denies that and has denied it in the filings in Nevada, but also we have a whole wealth of legal filings that make allegations back and forth. So here we are. They say that given Miss Westbrook's YouTube status, it's more than reasonable to assume that the pleadings filed in this case will end up being broadcast on the internet, making the Westbrooks' inclusion of the improper touching allegations in their counterclaims all the more concerning. Indeed, one YouTube commenter has already published the salacious material in the Westbrooks' opposition and declarations in a video that has been viewed over 27,000 times. Footnote 2. What? Hi, I'm Emily D. Baker. We cover legal pleadings from both sides on the interwebs. But we didn't even get to cover it that much because that was the day Good Logic was on. But yes, we covered it. Thank you for the hyperlink, I suppose. We cover lawsuits here, people. The Westbrooks attempt to recast their defamatory statements under the guise of counterclaims, and now with the submission of declarations which are equally irrelevant to their counterclaims should not be tolerated. Footnote 3. It won't jump down the page. Footnote 3. It just won't do it. Footnote 3. For that reason, the court should also disregard the defamatory statements repeated under the cover of declarations submitted by the Westbrooks opposition, which are completely unrelated to their counterclaims, according to them. In sum, the Westbrooks have abused the process of responsive pleadings by including irrelevant allegations in their counterclaims, and these irrelevant allegations should be stricken. As the Washington State Supreme Court said when it affirmed the trial court's striking of immaterial allegations, quote, under our system of pleading, the technical learning of the common law pleader is of but little account. The plaintiff is required to state his cause of action with sufficient particularity to apprise the defendants of its true character. The defendant, in his answer, must deny the facts alleged in the complaint, or he must state new matter in avoidance or by way of counterclaim. With these fundamental principles kept in view, there ought to be little difficulty in framing correct pleadings. You also need a date. Triller, you need a date. Triller, you need to put dates in your pleadings. Just saying. In this case, the defendant denied all the matters averred in the complaint. It's been a long time. I don't always read appellate case law. It's been a while. No one uses averred except for appellate judges. His affirmative, what year is this from? 1900. Good. Okay. I felt like we were in the Wayback Machine. Oh, this one's 1885. I felt like we had gone into the Wayback Machine. I felt like I was having a law school moment, and good. I'm glad that we are, but also the fundamental principles of law. Let's continue with the fundamental principles of law. With these fundamental principles kept in view, his affirmative defense cannot be construed as doing more. Neither the supposed affirmative defense nor the reply to it added anything to the issue, which is fully and completely made up when the defendant denied that it made the contract described in the complaint. They go on to say the same logic applies here. The Westbrooks' denial that their attorney's letter contained false statements fully and completely makes up their defense. Okay. Their counterclaim's inclusion of allegations of touching and unprofessional conduct adds nothing to that denial. Okay. And because the Westbrooks' counterclaim seeks no affirmative relief based on the alleged conduct, their allegations are immaterial and impertinent and serve no purpose in this lawsuit except to scandalize. Conclusion. For the foregoing reasons, strike that shit, Your Honor. Strike it. The court has declined to acquiesce to that request. So let's get to the court's ruling. The court ruled on December 10th. What's today? The 14th? On December 10th in lots of pages in duplicate, but filed December 10th, King County Superior Court, where order denying plaintiff's motion to strike. Notice this one's not signed. This was the proposed order denying the motion to strike that was filed. This matter came before the court on plaintiff Clark Swanson's motion to strike. The court has reviewed the pleadings and files of record and is fully advised. Now, therefore, it is hereby ordered plaintiff's motion to strike is denied. And that was the proposed order. This is the signed order. Swanson versus Westbrook, order denying motion petition signed by the court. So the court, this is the electronic signature page, meaning that this order in its simplicity is signed. That was the electronic signature page. The court has denied the motion to strike. The court is like, nah, look, what we're going to do is settle this in its entirety, but the mudslinging, it doesn't seem, is going to end. And again, lawsuits are allegations and shade. These are allegations made by both sides. Tati filed a declaration. We covered that. Swanson is saying these are only placed in to scandalize, and calls the statements, let's see, I didn't see a flat out denial, but calls the statements, says there is a pattern of defaming and disparaging behavior, and says that these statements, what do they say? Where do they deny it? Um, that the allegations allege Mr. Swanson engaged in inappropriate touching and unprofessional contact. There we go. Well, Swanson denies that the Westbrook's allegations are true. So there's the denial. The allegations, truth is not at issue in this motion. So they're saying Swanson's denying the allegations and saying they don't need to be in here. This is just to continue a smear campaign on Swanson. So that is denied. And we will see what happens next. We've got an answer in this case. We've got a complaint. We've got an answer. And whether there will be motions, I don't know. Whether they will just hit to discovery, I don't know. We will see. So that's not the only one. We will check back in on the California suit that's going to be moving and the Nevada suit soon. We've been covering so much other stuff. Ugh. So somebody, the chat, it moved too fast. Missed opportunity to use the word, see, I can't pronounce scurrious very well. So I'm fine. I like spelunking, but scurrious, I can't pronounce. So I am terrible at pronunciation. We know that. All right. Yeet. Motion denied. And we need to move on because we need to get to that contempt hearing. And so we're going to swoop and then we're going to get to questions because it is time. It is time. It is time. And then I'm going to try to rejoin that hearing and I will share on social. So if you aren't following me at the Emily D. Baker, you should, because that is where I am following it. All right. Contempt hearing. What is going on? What contempt hearing, you say? Well, with regard to the Girardi case, Tom Girardi's law firm was representing a number of plaintiffs in the Lion Air disaster. Edelson PC was co-counsel. Edelson PC filed the lawsuit that kind of tipped it all and was the top of the iceberg, alleging that Tom Girardi was stealing funds from widows and orphans, alleging that the divorce of Erica and Tom was a sham, and making other allegations, suing other members of the law firm. That lawsuit really is what kind of kicked off the media attention, it seems to me, to what was going on as Girardi Keese was crumbling. Before the bankruptcy, before the hearings, before the season was being filmed, that lawsuit happened. So when that lawsuit happened, the judge in Illinois covering the Lion Air disaster case started asking a lot of questions like, yo, WTF is happening? Why haven't these plaintiffs been paid? You got money from Boeing. You haven't paid the plaintiffs. That is the judge that froze Tom Girardi's assets. That is the judge that held Tom Girardi in contempt. That is the judge that asked Girardi, where is the money? And Girardi's lawyer was like, we don't believe there are any funds. We don't believe he's competent. And that is really what started it all a year ago, December. That has finally come up for a contempt hearing. This is day 3 of that contempt hearing. Attorneys from the Girardi Keese firm have been testifying in that case. David Lira and Keith Griffin. I'm going to call them Lira and Griffin so I don't mix up their first names. Lira being Tom Girardi's son-in-law, Griffin being another lawyer with the firm, both being seasoned lawyers with like more than 20 years of practice, both testifying that they were W-2 employees, that they were not in charge of the firm's books, though one of them was a signator on the books. Both of them saying that they were trying to fix it, but both of them really saying Girardi was in charge of everything. It's not us. Today, Jay Edelson from Edelson PC is testifying with regard to what they were told when they were told, because the court is like, look, Edelson PC, you're not off the hook here either. Like, why didn't you bring it to the court's attention that these clients hadn't been paid? Your co-counsel, what, why aren't you involved? And I think the court's exact words last week were, you might be in this too, or you might be in the soup too, something of that effect. So with all of that, there have been several reports regarding this hearing. The first one we are going to go through together comes to us from Bloomberg Law. And then we'll go to Law 360. And yes, we're going to take some water because the throat. All right. Fear of Girardi, no excuse in lawyers' contempt proceedings. A federal judge in Chicago said he wouldn't entertain arguments that Thomas Girardi was so powerful that his former colleagues feared taking action when they learned of his failure to immediately forward millions of dollars of client settlement funds. A coercion defense isn't persuasive to me. I don't care who Tom Girardi was, Judge Thomas Durkin said after one of two former Girardi Keese lawyers defending themselves in contempt proceedings testified that he remembers being very scared of Girardi. Girardi was politically well connected and vindictive, Keith Griffin said. Both Griffin and David Lira had been practicing for at least 20 years when confronted with their question of what to do when they learned that their boss was mismanaging their clients' money, according to testimony. They argued that they were merely W-2 employees. We heard testimony today, by the way, that Griffin's W-2 income was over $700,000 for the year, which I thought was interesting, kind of seeing what those W-2 numbers were based on how much money this firm was bringing in and based on other testimony that we'll touch on. That they were merely W-2 employees with no authority over the firm's finances, and that a court order involving finances, which was issued to the firm, didn't extend to them. Girardi, whose representatives say he is suffering from dementia and who has since been declared mentally incompetent by a state court, he's in a conservatorship, said in an affidavit that if called to testify, he would assert his constitutional right to remain silent. The former firm CEO, Chris Cameron, did the same. I believe this name, he also had something to do with the finances. Lion Air. The contempt proceedings began with a motion to show cause filed in December 2020 by Chicago-based law firm Edelson PC, which is serving as a friend of the court in the contempt proceedings. Edelson was Girardi Keese's co-counsel in litigation against Boeing, representing family members of people killed in the 2018 crash of Lion Air Flight 610. Email correspondence among Lira, Griffin, and Girardi's longtime assistant shows that both Lira and Griffin knew by May 2020 that Girardi was planning to send fabrication-filled letters to their clients to buy the firm more time on delivering the funds, and that Girardi had only made partial payments despite no authorization or legitimate reason to pay in installments. Now, this came up today in the testimony as well, that there are times when plaintiffs' firms will help stagger out payments for tax planning purposes or what have you, but that is required to be signed off on by the client, and that was not done here. They say at least two of the letters were sent despite the attorney's efforts to stop them. I mean, but we heard testimony today that Girardi didn't use a computer. We saw Erica Girardi leak apparent text messages between Tom Girardi and someone he was alleged to have an affair with that were coming from a flip phone. We saw Erica at the reunion say, with snark, that she was trying to message back someone she thought Tom was having an affair with, quote, "nice tits, stupid bitch," end quote, said at the reunion, but that she had to do it on the flip phone and couldn't push the space because it's like 3 letters to 1 letter, so it was all like one word. So look, if the other attorneys are saying we couldn't stop him from sending out the letter, how was he sending out the letter? Was he emailing it? Was he putting a stamp on it? How? How could you not stop him? I don't understand the ins and outs of that. Just how could, what? Okay. But they could not stop him, apparently. Neither of the attorneys told their clients that Girardi was lying to them. At least now we are looking at the people who could have stopped some of this, which I appreciate. And thoughts and feelings about Erica and her social media presence aside, she was not a lawyer at the firm. At least we are now questioning the lawyers at the firm, and that question should be, what the fuck is happening? And that is what is happening here. because now we're learning that exactly what the fuck is so much worse than what I imagined. They knew he was sending letters to the clients that were fabrication filled. Okay. Neither of the attorneys told their clients that Girardi was lying to them or reported Girardi's handling of the client funds to any disciplinary authority. Griffin said that he eventually consulted ethics counsel, but it wasn't until November, just 2 weeks before Edelson put the court on notice that the money was missing, when they filed. And Edelson talks about this timing in the testimony that I heard this morning. Griffin said he never imagined that Girardi wouldn't pay their clients and that he didn't know he was in financial trouble. The firm received the money from Boeing in March 2020, which we've learned in these hearings. March 2020. Edelson didn't file until the beginning of December. Girardi Keese got the money from Boeing in March 2020. The thing is that is also right at the beginning of the pandemic. And it seemed that the beginning of COVID allowed for this perhaps to stretch, because now you've got people working from home. LA locked down on like March 14th, 17th, right in there. So now you've got people working from home. Everyone who I've seen describe the Girardi Keese firm, and Jay Edelson talked about it today in testimony too, said that this firm looked like something out of the 70s or 80s. Paper everywhere, things not being done by computer, Girardi having 2 secretaries to deal with things, him never using a computer. So you can see why some of this, like, oh, we're not there, we can't handle it, et cetera, et cetera, et cetera, might have actually been persuasive to some, because they'd seen that the law firm is not a high-tech law firm. And that's exactly what we've seen in this bankruptcy too. The bankruptcy trustee described it as literally like piles of papers with like trails through them in this law firm, with no organized accounting system and no real organized technology. So we've heard that multiple times. So you've got now a firm that is not technologically savvy, that isn't really dealing with things in an up-to-date way. And we're dealing with a payment coming in right at the beginning of a lockdown. But that's still not an excuse. It's just by way of compounding what happened here. So the firm received the money from Boeing in March 2020 and was required to wire the money within 30 days. Instead, it made partial payments and they were late. Griffin, who was on the stand most of the day Wednesday, said he urged Girardi to comply with the court's order and pay the clients their full settlements. The court actually asked Edelson about this today, and we'll get to that. But Griffin said that he urged Girardi to comply with the court's orders and pay the clients their full settlements immediately, but was relying on Lira to intervene. Griffin said he believed that Lira, who was more senior, was in a better position to influence Girardi. Lira said he tried. Lira, by the way, being the son-in-law. Lira told him he was risking 50 years of legal work and that this was wrong. It wasn't his money and it had to be paid, Lira testified Thursday. Lira said he specifically remembers reminding Girardi that his family name was on the advocacy center at Loyola Law School in Los Angeles. He said Girardi listened, nodded, and told him he'd take care of it. Lira is also Girardi's son-in-law, but said they weren't close. Lira said Girardi had zero relationship with Lira's children. These would be Girardi's grandchildren, and had only visited his home a handful of times in the last few years. Like, I have questions. I have questions about how this all went down. Your son-in-law works for you and you're not spending time with him or his kids outside of work. Like, what is going on here? I have so many questions about that. When he resigned in June 2020, this is March, they weren't paid. April, May, June. So we're now, 3 months after they should have been paid, given the 30 days that he resigned from the firm. Lira said he called Girardi a thief. Girardi begged Lira to stay, saying he would resolve everything soon after, Lira said. He said he learned a few weeks later that Girardi didn't follow through. Lira admitted when pressed by Durkin, that is the federal judge who's been asking quite a lot of questions. Lira admitted when pressed by Durkin that there were other things he could have done when he learned that only half the money had been paid to the Lion Air clients. Yup. Let's get into it. He was a signatory on the trust account and acknowledged that he could have gone directly to the bank and demanded the trust records. He was in a position to actually do something. He said that Cayman refused to give him, he could have gone to the bank and demanded the trust records that he said Cayman refused to give him. He had authorization to sign checks without a second signature, but said he didn't realize it at the time. Questions, questions, questions. Girardi, the firm's sole owner, was found in contempt last December. After Girardi told Durkin that he didn't have the balance of the $2 million he owed his clients, Durkin referred him to federal prosecutors. He has yet to be charged with any crime. We will see what happens there. Exactly how much the clients were supposed to receive is unknown because the underlying settlement agreements with Boeing are confidential. We know that it's $2 million plus some, based on the public court testimony. Edelson has accused Girardi of operating a kind of a Ponzi scheme, and evidence shows that Girardi paid some of the Lion Air clients with attorney fees from another case that came in September. In the afternoon, Durkin called Griffin back to ask about another Girardi Keese client not covered by the court's order, who also failed to receive his settlement money from Boeing. He then called Rafi Balbanian, Edelson PC's managing partner and general counsel. He was the one who was mostly liaising with Girardi on this. Jay Edelson being the head of the law firm, but Balbanian being the one who was dealing with the day-to-day of dealing with Girardi, of sending most of the emails and then keeping Edelson apprised. And that was to probe whether Edelson had its own obligation to notify the court prior to December 2020. In their briefs, Griffin and Lira argued that in so much as they had an obligation to do more than they did, so did Edelson's lawyers. So yeah, we could have done something. We, the lawyers that were seeing Tom Girardi's face, that knew him, one of them was family to him. We know that we had an obligation, but so did the lawyers in Chicago. So, Your Honor, but they could have done something too. It's different to me, the lawyers in his practice, seeing him day to day, than co-counsel in the middle of the country in Chicago who are not seeing him on a day-to-day. It is different to me. And I think that the court might find that those two things are different. We will see. Mr. Unicorn is just making me laugh in the chat, saying, sounds like Ponzi schemes are all the rage. That's what we hear. That's what business partners are alleging. Well, this is members of the firm are alleging. These are employees alleging, I suppose. No. This isn't kind of a business partner situation with a local counsel, so maybe. Durkin wanted to know whether Edelson had at any point before September 30th, when Balbanian says Girardi told him unequivocally that the clients had been paid, contemplated coming forward to the court to report there were problems with the court's order being followed. Balbanian said they had considered it, but ultimately decided the explanations were reasonable in terms of Mr. Girardi's ailments, in terms of it being the result of a mistake. We'll talk about that more in a minute. Durkin interrupted to ask, isn't that really for me to decide, though? Clearly, if you knew that half got paid, then you knew. And if you didn't know, then Schrag did, because he knew what the other settlement agreement said, Durkin said, referring to Edelson partner Ari Schrag. You had to have known as a firm that there had been a violation of the court's order, being the 30-day payment period. Durkin said, Schrag appears to have done a lot of the communicating with Griffin. You may be in the soup too, Durkin later said. Durkin continued the hearing to a yet-to-be-determined date today, so that he can question further both Schrag and Jay Edelson today, the firm's founding partner, about what they knew and when. Balbanian said at one point that some of the conversations with Girardi felt like the movie Groundhog Day, as though their previous conversations had never happened, which I think sheds some light onto the questions about Girardi's mental state and whether or not there was lucidity or mental decline before that was determined after the bankruptcy started. Girardi seemed unwell and out of sorts at points, he said, but when asked directly by Durkin, Balbanian said he had no reason to doubt Girardi's mental competency. Lira, and then this is who everybody's represented by. So Let's talk about what happened in court today. We learned from Jay Edelson that they did, in fact, contemplate filing motions with the court sooner, but felt that they didn't have enough evidence. He referred to it as jello. Like, we don't have enough to stick to file these, and we don't want to hurl these massive allegations at another lawyer without it being true. Jay Edelson testified that he was told by other attorneys, look, just get Girardi to sign an agreement and have him pay it. At first, Edelson said they thought that the reason that Girardi was being kind of coy with them, that's not the exact word he used. It was something along those lines. But the reason Girardi was being cagey with them was that he was trying to avoid paying legal fees. And Edelson was like, this happens sometimes with co-counsel. And he said, our firm kept saying, if this is about our fees, like, we don't care. We just want confirmation that the clients have been paid. And they were being told that the clients had been paid. So from the time that money was funded in March, you got testimony from Edelson that he did not know the clients had not been paid. He also didn't know that Boeing had paid Girardi until after June, when he was told that clients had been paid half. He also said that that is not always super uncommon with tax planning, that can happen. The Girardi firm was the firm in charge of communications with the clients in Indonesia. And that, excuse me, voice. I apologize. So that with COVID and with what Girardi was telling him, that Edelson believed that there was a clerical mistake. But Edelson also said that he was told, and it was communicated to him, that Girardi had been in the hospital, that Girardi had a brain tumor behind his eye that was cancer involved or cancer related, and that is what he was being told. So that for Edelson's mind, it was, okay, we've got this older lawyer who is saying, my throat is just getting so sticky. Apologies. This older lawyer who has this whole paper filing system, who's been in the hospital, who is, not able to get into the firm in the middle of COVID, that's in his 80s. So Edelson was saying that he believed it had been a clerical error or a mistake because that's what he was being told. And that it was after that he started, and his firm started pestering Girardi to try to get some answers. And Edelson said, it's like our voicemails. I'm a nice guy. It's a mistake. Don't do this to me. And the things that were included in that initial Edison filing from now over a year ago, that had the links to those voicemails. So it's very interesting to see how Edelson was talking about the way that they were put off in not knowing. And what was very interesting to me is when the court asked very directly, have you considered paying this out of your own pocket? Edelson did not have the most direct answer. The judge had to ask again and kind of got down the road to where Edelson said it's something that they would consider. Edelson said at the end of a line of questioning from the judge, we've thought of a lot of ways, including from our own pockets, to make this right. But Edelson said the firm is out over $2.5 million of their legal fees that they're not expecting to get back, essentially, and that they cannot necessarily cover $2 million plus to pay back the clients. And the court's like, at the end of the day, how are these clients going to get paid back? And the court seems very focused, thankfully, on how these clients are getting paid back. So Edelson did say that they are trying to be very active in the bankruptcy and go after money for the clients, but also did not directly say, yes, we can pay them back. Said, we've considered it. We're not ruling it out, but we cannot. So that was very interesting because the court was like, at the end of the day, how does this get paid? The information about Jay Edelson's conversation with Tom was very interesting. The court interrupted and said, did he seem lucid or cognizant? And Jay Edelson said, in our conversation, yes, because I asked Tom how much he had stolen and he told me. So that was when it got around to the $2 million. And Edelson said, I told Tom Girardi on the phone, this is going to be, and I quote, very, very bad for you, Tom. And Tom said, I should get off the phone. And so he said, to me, I think that Tom was aware of what was going on because he knew how bad it was and was like, I need to get off the phone. Because I'm being asked questions I shouldn't be answering. So the other part of that conversation was that Jay Edelson told the court while he was testifying under oath that Tom Girardi started calling after the order to show cause was filed, asking to drop it, saying that it was a mistake, and then saying, quote, he could make me a ton of money because of his connection with judges in California. What the fuck? So Jay Edelson testified that Tom Girardi said to him that he should drop it and that Jay could make a ton of money because of his connection with judges in California. And Edelson said, Tom, how much money have you taken? And Tom said, 500 each, which to the clients. And Jay said, so 2 million in total. And I said to Tom, this is going to be very bad for you. And Tom said, I should get off the phone. And the court interrupted and said, wait. Did he sound lucid? And Jay said, yes, he knew the amount of money that was missing. And the court said, he said to you, you can make a ton of money because of my connections with judges in California. And Jay Edelson said, yes, that's what he said to me. So now we have Tom Girardi seemingly to attempt to bribe Jay Edelson. That's what I took away from hearing that. Jay Edelson also said he thinks that this is the tip of the iceberg with Girardi Keese, that he thinks there are more people responsible and involved in this. Jay Edelson said that other attorneys had warned him to stay away from this. He said that he knew that his firm might take a hit on this and get kind of dinged by the court. He said it on Twitter and he's like, I just don't care. If I get big, like if our firm gets binged in this, I just don't, whatever. Should we have come forward sooner? Maybe we were. Jay Edelson said, in my 25 years, I have never seen anything like this. And Tom Girardi stealing the money was the least likely possibility. He actually mentioned Occam's razor. He's like, the most likely possibility was that this was a clerical error, that this money came in at the beginning of COVID, that he was in the hospital. We're told he has a brain tumor. He's in his 80s. It's COVID. He's got this paper filing system that's a shit show. And we didn't know. It seems more likely that this was just a mistake. It seemed the least likely option that he was stealing from clients. And so Jay said that's part of why we wanted to investigate before we made allegations like that. Just wow. Just wow. So, Jay Edelson really did lay out why he and his firm waited. And then he laid out that it wasn't until he saw Erica filed for divorce that he really started to believe that the money was gone. And it was his impression, and he wrote this or his firm put this in the lawsuit. It was his impression that with Erica leaving, that it indicated to him that the money was gone. And there was an objection, and the court's like, no, this is his impression as to why he filed in December. And he filed in December because Erica filed for divorce. And Edelson's like, it seemed to me that their marriage was transactional, and when the money was gone, she would be too. And so her filing for divorce was an indication to us that the money was probably gone. And the only thing that we could conceive of is that then maybe, truly maybe, the money got stolen. And then there was that phone call with Girardi where he said that he had taken the money. It's just fucking wild. So we'll see what happens the rest of today. I'm sure this contempt hearing will be, it's probably resuming now. It's 2:00. I'm going to try to attend the rest of it today. It is really wild stuff. But I think my biggest takeaways from today's part of the hearing was that money got to Girardi Keese at the beginning of March is when it was funded, that some of the clients got paid partially, that the Edelson PC firm really did believe for quite a number of months that this was a mistake, that Jay Edelson was told and that his firm was told that Tom Girardi had a brain tumor. Let me find the exact language because I was typing so freaking fast because I wanted to get some of these things accurate, that he was told that Tom had a brain tumor that was cancer related behind his eye, which is this when Erica's like, Tom had to have surgery on his eye? Did he have brain surgery? Did that happen? Did did that happen? And was that connected to the burglary at the house? And was there more mental decline than we know? Because we now have another lawyer saying some of this seemed like Groundhog's Day. And were the lawyers in law in Tom's firm when they're like, Tom, this is really fucking bad. And he's like, yeah, I'll take care of it. Did they know that he was having mental decline? Like, what is happening? Ooh, the judge's ruling on this, just my gut impression is that the judge's ruling on this is going to be a very thorough document laying out the malfeasance or misfeasance that went on, laying out what he thinks others could have done, and really laying out everything that the court found happened here. And we're going to, the second that is available, we are going to go over it because that ruling will be very, very interesting. So, woo! That is what we're learning from Jay Edelson on the stand. They were starting cross-examination and then taking a break for lunch, so I know that I've missed some. I'm going to rely on the reporting of Law 360 and Bloomberg for what I've missed, but those were the big takeaways. And of course, the thing that sounds like bribery. Mhm. I can make you a lot of money. You should make this go away. I can make you a lot of money. Sounds like it to me. That's just my impression. That's the impression that I get when it's like, let's let this go. vidIQ. Hello, vidIQ. Welcome, Vidiots. But that's the impression that I get when it's like, you should drop this. Be nice to me. I know a lot of judges. We can make you a lot of money. Wow. Wow. All right. It is time to get to Q&A. It is, I can't believe we're 2 hours in. It is time to get to a quick Q&A, but that's what we learned. And we'll be covering it. That's what we learned. Call me Al. vidIQ must have just finished their Tuesday stream where they do channel reviews. I think they're just saying hello. I love working with vidIQ. And they have recently hit 1 million. We are working on getting to 200,000. So if anyone's coming over from vidIQ, hello, welcome. You have to be subscribed to chat because subscriber mode's turned on. So it kind of thwarts the rating. I apologize, vidIQ. But also, welcome to all of the vidiots. All right. So we will see. Rob, Dan, Viper, Savage, but you all can't chat unless you're subscribed. So, we do what we can because we talked about a whole lot of shit today. Let's get to questions. I have questions. You have questions. We have questions. This was a lot today. We covered a lot of topics. Thank God for chapters. All right. Questions at 2 hours. And then I'm going to get back on that hearing. God, 5 years ago, if you had said, hey, Emily, when you leave the DA's office, what you're going to spend your day doing is sitting in on contempt hearings in Illinois for a case that is not your case, I would have said, no, I'm never sitting through a court hearing again. Okay, George, I hear you. Did you hear that? Why are you so loud, George? I don't know if you can hear him. I have a directional mic, but George is in here yelling at me. Oh, no, that was Fred yelling at me. Hello, Fred. So let's get to it. Oh, Sticky said, can't chat if not sub. Sounds like bribery. It's a control mechanism. People don't have to chat. Chat's a bonus. But yeah, we had subscribers mode on today because we were talking about stuff when we talk about stuff that can get polarizing, it's just easier and it's easier on the mods. And especially when the chat gets into the 5,000, it's just easier to have subscriber mode on. So that I like subscriber mode. We don't do subscriber mode on every chat. We don't do it when we invite guests in so that their communities can come in and decide if they want to subscribe. But we absolutely use it when we can. So everybody's saying hi, Fred. For the love of God, Emily, please have a drink. I'm trying. We're trying. Bruce Leetta, hello again, Emily. I used some purple just for you on my thumbnails. I promise to come back and review this one. I will absolutely take a look at it for sure. We will timestamp. I'm sure somebody has. Question. What time frame do you give any of the Girardi victims to get money, if at all? Oh, Lillian, I don't know. It's such a mess. it's shocking. And I can understand Jay Edelson being like, this is shocking. And I shared what he had tweeted about it. And there has definitely been back and forth on Twitter about it. And I've shared that. But it's just such a mess. Eh, so I don't know. I know that I appreciate that this judge is asking the right questions. I think this judge is like, look, where's the money and who's going to pay it? Who is paying these people? And I want to see if Griffin and Lyra and Edelson PC, between the three of them, are like, here's $2 million. Let's get these people paid. And then they can go sue all the people to get reimbursed, which is what is happening in the Murdaugh case. So I covered it a while back on the podcast. I need to loop back around to it, the Alex Murdaugh case, but it came out that there was client funds stolen. It doesn't seem to be as big as this is based on what's been reported thus far. But the firm is like, we have paid everyone back. And then the firm sued Murdaugh to get the money back. But I don't know if that's what will happen here. But the judge asked more than once, can your firm pay it back? I'm not saying you're legally obligated to, but is that something you're considering? And it does seem to me, my impression, that the judge is very focused on getting this money to the victims from the Lion Air case, and that Edelson PC is focused on that too. But there are other cases, there are other victims, and it is wild. Is the hearing open to the public? Yes, Destiny, it is. I posted that on Twitter. I posted the minute order that has the call-in information. It also has the rules. So just check the rules as you call in. And yes, it has all that call-in information. So Jordan said he filed it because he felt it would be proof of their arrangement for how much he gets of their business, but they continued negotiating and had a later agreement in writing. That is referring to something else. But yes, this is why I generally go with questions, because you were talking to somebody else and I just picked it up in the middle. Hello, Fred. Say hello to the law nerds. Your toes are cold. Where have you been chilling? Where have you been chilling? Your feetsies are cold. Question. Can Ethan get all his lawyer's fees paid for? I don't see how it's fair to keep getting sued and spend so much on lawyers. If he wins, yes. Especially if he wins on anti-slaps, yes. If he doesn't win, no. So, Emily, thanks for the awesome analysis. Re Cav versus Klein. The most interesting line of attack is implication by defamation. Clarity on this. Again, if it's true, if the allegation is true, I still don't know how you get to defamation by implication on that case. It is an interesting, oh, well, if you strongly implied somebody's doing the thing, but then you have to look at the entire context of the H3 podcast. And I think that even if that went to a jury, they would look at it and say, this is somebody who's poking at or making fun of or taking the piss out of someone else. Is he trying to imply that is Ethan Klein trying to imply that Kavanaugh ran a Ponzi scheme, or is he poking at the person who's suing him saying, well, his partner alleged it, and the implication is not that he ran a Ponzi scheme, but the implication is that Ethan Klein thinks he's a piece of shit. And if that's the implication that a jury takes away, you're allowed to call somebody names on the internet, as long as they're not defamatory. There's some names that are defamatory. So it depends. But yes, but if the underlying thing is true, that the allegation was made, which it seems to be, it's in a signed court document that was not filed, but is attached to that Variety article. So if the underlying thing is true, I don't even think you can get to the defamation by implication, because it's like, well, every time he said it, he said alleged. Fred pulled up your question by stepping on my mouse. Please don't step on the mouse. It is not a mouse for you to play with. It is my mouse. But Fred stepped on my mouse. I use a touchpad mouse. So occasionally Fred will, respond to DMs and pull up a comment. And he is just like, I'm going to just be here today. Hi, buddy. He's just ready. So, hey, Emily and Lawners, just wanted to say thank you for helping the tornado victims. My daughter lives in Dawson Springs, Kentucky. Her and her family are fine just without water, which just being without water would be hard too. All of it's hard. Emily, someone asked if the illegal recording would be submitted so we could hear you cover it. The illegal recording is referred to in court documents. I will go and look. I believe some of the court documents have a transcript, but no, I can find the transcripts. I think the transcripts have been submitted of conversations that went back and forth, but that's what the recording is of. The recording that's being alleged to in the Toddy documents is the recording that Swanson says is proper, that the Westbrooks say was illegal and surreptitious, and it is of a business meeting. Um, and I think the transcripts I don't remember what the transcripts were connected to, but the transcripts or part of the transcripts were connected to something. Trying to figure out which file those are in will take me a minute because I don't remember if they're in Washington or if they were submitted in California or Nevada. They were submitted in one of the three lawsuits. Question, do you work more now than when you were in court? Do you take breaks? I don't take nearly enough breaks, KV. You're welcome for the updates. And I work quite a lot now, but it's on my own terms, so it doesn't feel as stressful. But I definitely am busy. The difference about being in court is my days are a little more harried and less at my control. And I think there are more cases that I'm covering now with more filings. Criminal court, criminal trial court at the state level isn't as heavy. Oh, hello. I see you. Okay. Isn't as heavy on written filings. It's much more police reports and in-court and investigation. Civil matters and federal criminal matters have a lot more law and motion practice with written. So a lot more that we're covering. Don asks, are law firms required to carry malpractice insurance? If so, would that pay off the clients? Girardi Keese did not carry malpractice, it seems, from all of the filings that I have read. And they are not required in California, though that may change after this. They are not required if they notify their clients that they do not have malpractice coverage. But I think the Girardi Keese reputation, probably most clients would have been like, I don't know why that would matter. It's fine. This is a firm with a great reputation. Fred, do not chew on cords. You trouble kitty. Stop it. Fred is trying to just chew on my wrapped. Stop. Here you chew on my wrapped cord from my microphone. Fred, you are such a kitten. We don't chew cords. No, we don't. No, we don't. We're gonna have to put something bitter on that. Fred's like, no, that's what we do. Vipe, what's up, man? Good to see you. Is this decision for Tati's Washington case beneficial for other cases? Not really. I don't know why they made the motion to strike, other than we're mad that it's said in court documents and being covered, but it was already on the record. So I don't really think it will impact the other cases, if that helps. Hold on. Somebody asked about Chauvin's plea. Chauvin's plea, I need to go and look exactly what he pled to, because I believe he pled on the civil rights violations, which are not necessarily lesser included. So I would need to go and look, Rachel. I have not followed it super closely because so much else has happened. So that's why. Sinister Moon said, so relieved we don't have this jury system in Norway. Our system is complex and multifaceted, and we've got state and we've got federal and we've got municipal. It is not an easy system. Fred. Question, will you be covering the updates on James Charles and the former employee? That case is up on appeal. I have not double checked to see if it's come back yet, but when it does, I will. It might not be close in time, but when it does, I will. I want to go make sure I hear for the Fred chaos. Fred is chaos right now. Question, if Ethan wins one case, will they have to pay the lawyer fees for all the suits? No, it will go case by case. So if he wins on the slap motion in the California LA case, which seems like a likely possibility to me, then it's just for that suit. Then how that ruling impacts the other suit, we will see. Fred choosing violence today. Let's see. All right. Let me make sure I tried to get to all the super chats and say thank you. Because truthfully, those super chats are going to go directly into paying for 800 pages of Triller legal documents. That's exactly where this month's super chats are going. And if you're curious, I will let you know how much those cost. I don't say that to ask for super chats. I say that because it's part of where my income as doing this goes. Because some of these filings, I feel personally attacked because they're so large, and some of them are just some courts are expensive. Like Washington is 25 cents a document, 25 cents a page. And some states are free. It just and some are 10. So, it just depends on excuse me, it just depends on the state. So the 800 pages is going to be here, I'll tell you. Oh, I'd have to log back in. We gotta do we can you get the 800 pages from Ethan? I prefer to buy my documents. And the reason I prefer to buy my documents is because I am not working with anybody's lawyers. I just like to cover these cases. I am a bystander here, and you know how I feel about the Trillery lawsuits, but I buy them. They are my opinion. Um, and I have not talked to any of the lawyers involved in that case. I I will only reach out to lawyers if there's an answer needed, like when I reached out to Salty or when I reached out to Erica Girardi's lawyers. And that's generally when lawyers have commented. So I'm sure if I asked Ethan, yes, but I would prefer to buy it. It is, look, we are a full-time content creator. That's what we're doing. So, um, thank you so much. Psychedelic Yoda, love your lives. Appreciate you. Oh, Amy, thank you. And again, I don't say that I just say that because that's part of where this goes for. Um, why would you have to buy documents? I'm so confused. Allison, they are not free. There is a processing fee, essentially, from the different courts. So the documents are a different cost. I forget how much LA charges per page off the top of my head. Washington, I was just downloading documents in the last day or two. And so those are very much at the top of mind because they are 25 cents a page. Pacer is like 10 cents a page. And then California, I think is 25 cents a page as well. I forget, but yeah. Um, why do you have to pay per page? Isn't it all digital? Yes, it's all digital, but the courts charge for that, for making them accessible, for maintaining their system, for all the things. So the courts absolutely charge different courts charge different amounts, which is why I try to pull them and try to break them down for everyone. So, yeah, I think LA's 25 cents. I bet again, off the top of my mind, I'm not remembering. Question, can you please cover the Nichelle Nichols conservatorship elder abuse case? It's worse than Brittany's. She has a hearing coming up on January 10th. I've got words. I am not aware of that case, but if you want to DM me on Twitter or on Instagram with the case number and the name, I will absolutely put it on the list. So, yeah. Catnip, whiskey, court documents. It's all with the tip. Thank you so much. Thank you and the mods for what you do, and everyone do the YouTube things. Yes, I forgot. No, foot soldiers don't need to start a fundraiser. Start a legal fees fundraiser if you're going to. Don't worry about that. We will take care of it. I just wanted to share that when I get hesitant about buying stuff, I'm like, 800. You filed 800 pages. You filed 800 pages. But I've definitely spent. I'm gonna have to tell you at the year end, just for shits and giggles, how much I've spent on legal documents because it is. But that's again, I like doing what I do, so it is. It is all part of it. I was trying to pull up the super chats I hadn't read yet, so thank you. Thank you. Stephanie said, "Oh, trying to become a member." We got to that. Ada Ray said, just wanted to say I love your content. We got to that. Thank you. Rachel, I got yours. Thank you. Cassiopeia said, just a quick thank you for your amazing coverage of so many cases. You're welcome. Pam Marshall said, I told my manager I'm thinking about law school. She told me it would make me doubly dangerous since I'm already a CPA. Thanks for inspiring me. Pam, yes, there would be lots that you could do with a dual JD CPA, in not just the tax realm, but in the forensic accounting realm. There would be lots and lots of options for that. I say the same thing with tech. People with a strong tech background going into law, and it doesn't often happen that people with a like a software engineering or coding background go into law, but it is needed. Like tech understanding in law is needed, and it's something we saw a lot in the Rittenhouse trial of the lack of understanding of digital evidence and interpolation and pixels. It is so needed. Tech financial. What we don't need is every lawyer to have a background in political science. Hi, I'm a lawyer with a background in political science and political statistics. That's what we don't need. We need lawyers with more diverse backgrounds. Engineering backgrounds are great when it comes into patent stuff. So tech, engineering, all kinds of stuff. So Tracy Chappell said the California bar has given us Kim K and Tom Girardi. Take it all in, people. I'll take my chances with Kim. I mean, we know Kim's not going to be stealing money. She's like, we've got KKW Beauty and Skims. Like, we're good. We can do the legal work pro bono, which puts her in a position to do some good. And you know what? Good. I think we'll see Kim do some good. Sarah Marie said, in the meantime, Kavanaugh is offering $25K for dirt on Ethan and H3. What? I need to catch up on what I missed over the weekend. Somebody tag me in it. Enchanted Wing says, this is why we ride every week. Facts. 50 feisty and fabulous. Good to see you. Merry Christmas to my fave California attorney from your fellow Texas attorney. Thank you. Runner said, hey, Emily, thanks for the awesome analysis. You're welcome. We talked about that one. Good. I think we're caught up. Yay. I think we're caught up. I love your streams. You are a grail-shaped beacon. Thank you. That is the nicest compliment. The trophy emoji was the closest thing to a grail as I could get. I love that. Grail-shaped beacon gives me life right now. I'm still not sure about that. Siri, fuck off. I won't respond to that. I'm sorry, Siri. I did not mean to hurt your feelings. I need to change my watch around so that the dial's there, because when I talk with my hands, I think it hits the dial and activates Siri. Oh my. So Ethan won't let us start a fundraiser for him because of what happened with the FUPA fund. I have no idea what that is, but I will take a look. Towards the Triller shenanigans documents. Thank you, Natasha. I feel like if we crowdsource them, we should just crowd share them. Feisty Siri. Siri's like, I shall not answer that. There was a period in time where Siri would answer questions about Holy Grail. And it was amazing. Okay, so y'all, we are going to wrap. I'm going to jump back into that hearing. If you are following me on the social medias at the Emily D. Baker, that's where I will be following along that hearing and giving you my thoughts and impressions when it's done. I will be back here on Friday for Friday Night Live. I will be putting links and timestamping below as I am on that hearing. What else? I think that's everything. For the members, there will be info in Patreon and on the members about the quarterly Zoom call. For the mods, thank you so much for riding. I appreciate all of you. I will see you soon. Siri's about to take you to court for hurt feelings. Possibly. Siri's like, telling me to fuck off. It's defamatory. No, you just don't like it. There's a difference. Love you, Emily. Your Pokeball is still in your Pokeball is still in your amazing wall. There is a Pokeball down there. Do you know if there are lawsuits related to Wendy Williams? I don't know. But if you want to DM me, look, if you guys ever have tips on lawsuits, you can always email me. My email is in all of my social media handles. You can DM me. You are welcome to be like, hey, can you take a look at this? For sure. And I will take a look. Thank you all, law nerds, for being here. It is so much fun to chat with you guys about all that's happening in the law. We've got some exciting stuff coming up into the holiday weeks, and I'll be sharing that with you too soon. Yeah, thank you. Thank you for being here. Take care of yourselves. Take care of each other. Thanks for being honored. May the odds be ever in your favor. All the things. Time to roll the outro. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.